Good afternoon. My name is Kim Stanger. I'm the chair of our firm's Health Law Group. We are here today to talk about the third issue in our HIPAA series. In our prior series, or prior webinars a couple of weeks ago, we talked about the general privacy and security rules. That was kind of a basic overview for the frontline personnel. Last week, we talked about HIPAA and business associate agreements. Today we are going to talk about identifying and responding to HIPAA breaches. As far as the preliminaries go, you should have received an email with links to the written materials, including a copy of the PowerPoint presentations, an article I wrote on responding to HIPAA violations, and also, just because we like you guys, we've given you a sample breach notification policy. Like our other webinars, this presentation will be recorded and available for download at our website for free. If you have questions, please submit them to me. You can use the chat feature through this program, or you can just shoot me an email offline, and I'll go ahead and respond to those emails as they come in. Today we're going to be focusing on HIPAA violations. Now remember, HIPAA is not the only privacy statute that's out there. So to the extent that there is a more restrictive statute, you've got to comply with that more restrictive statute. HIPAA preempts less restrictive statutes, so you at least have to comply with HIPAA. In some of your states, there are some additional state laws you have to be concerned about when responding to potential privacy breaches. For example, California has an awfully strict medical privacy law, and it actually imposes shorter deadlines, additional requirements beyond HIPAA. If you're in one of those states, make sure that you are complying with your state law in addition to the HIPAA. In addition, all states have separate, or almost all states have separate laws that govern certain data breaches. For example, most of them cover something to the effect that if you discover that your computer systems have been attacked or hacked or improperly accessed, and there is a breach of data that usually includes the name plus a social security number or other identifier, then you have an affirmative obligation to report those breaches. If you fail to do so, you can get hit up with penalties, which are usually around $25,000 per violation. So, in addition to HIPAA, make sure you're aware of any of the state laws concerning data breach notification. Also, when responding to HIPAA breaches, make sure that you're aware of additional contract terms that may apply. For example, in your business associate agreements, you may have more restrictive requirements. For example, under HIPAA, it may require a business associate to respond or notify the covered entity within 60 days, but your business associate agreement may actually require shorter time frames for those types of responses. So make sure that you look at your business associate agreements when you're responding to potential HIPAA issues. Also, you may have additional confidentiality agreements that are out there. If so, make sure you take those into consideration. But with all of that said, let's talk about HIPAA. Brief overview, as you know and as we've talked about in the past, there's three parts to HIPAA. There's the privacy rule, the security rule, and the breach notification rule. We're going to focus a lot on the breach notification rule today. Can't talk about HIPAA without talking briefly about the penalties. This is really important because you need to know those penalties and the structure that applies to help you in responding. First, did you know that you can go to jail for a HIPAA violation? Yes, you can. The criminal penalties apply if an employee or other individual obtains or discloses protected health information from a covered entity without authorization. Now, the penalties are anywhere from $50,000 in a year in prison up to $250,000 or 10 years in prison, and 10 years in prison. Now, I bring this up in this context because in addition to potentially scaring you, you can use it to scare other parties. So, for example, if you've got a situation where an employee is violating HIPAA or information has gone to another person improperly, I will usually contact that person or send them a letter and let them know that, look, you got this information improperly. You shouldn't access or further use or disclose that information. If you do, you can be hit up with these criminal penalties. Remember, HIPAA civil penalties only apply to covered entities and business associates. That may not be a lot of your employees, but they would be subject to these criminal penalties. So I like to use this statute offensively in order to warn people against violating HIPAA to ensure that they toe the line. But for most of you, you're going to be primarily concerned with the civil penalties. And the way the civil penalties work, as we've talked about in the past, If you violate HIPAA, you can get hit up with penalties of anywhere from $100 to $50,000 per violation. The bad news is if you act with willful neglect, it's a mandatory fine of at least $10,000 to $50,000 per violation. That's the bad news. The good news is if you do not act with willful neglect and you correct the situation within 30 days, you can avoid HIPAA penalties. There is no fine under HIPAA if you do not act with willful neglect and you correct it within 30 days. That is an affirmative defense. What does that mean for you? That means that in responding to a HIPAA breach or potential HIPAA violation, you want to ensure that you did not act with willful neglect or that you document that you didn't act with willful neglect, and you want to correct the situation within 30 days. You want to jump on this immediately because if you do, you can avoid HIPAA penalties. For example, HHS gave the following example of a situation where the covered entity did not act with willful neglect. A hospital employee accessed the paper medical record of his ex-spouse while he was on duty, knowing that such access was not permitted by the privacy rule and contrary to the policies and procedures of the hospital. The covered entity had appropriate and reasonable safeguards regarding the employee access to medical records, and it had delivered appropriate training to the employee. Under that situation, even though the hospital employee violated HIPAA and may have acted with willful neglect, the government said, hey, in that situation, the hospital did not act with willful neglect. There was still a HIPAA violation, but the hospital did not act with willful neglect. That means that if the hospital corrected the situation within 30 days, they would not be subject to HIPAA fines. So the key to avoiding HIPAA penalties are to make sure that you have the required policies and safeguards in place, train your personnel and document that training, and respond promptly and appropriately to suspected violations. If you can do that, you can avoid an argument that you acted with willful neglect, and you can avoid HIPAA penalties. Those penalties can add up awfully quickly, as you can see from the recent settlements in 2015. We won't go into all of those, but in addition to the civil penalties, there are additional reasons why you need to make sure you're complying with HIPAA, including state attorney generals can bring lawsuits and recover a $25,000 fine plus fees and costs. In addition, this is actually a new issue that's come up. Well, it's not all that new, but I wanted to call it to your attention. The FTC has been filing complaints against entities that did not adequately protect or secure their clients, their customers' electronic data. The FTC has filed about, over 50 complaints against entities so far. So you may not only have to worry about HIPAA if you don't have appropriate safeguards in place, you may have to worry about the FTC. Affected individuals may sue you for violations. There is no private cause of action under HIPAA. They can't sue you for a HIPAA violation, but effectively, HIPAA may become the standard of care, so they may sue you for a state law cause of action, breach of privacy, negligence per se, so you got to be worried about individual suits. In the future, affected individuals may also recover a percentage of fines or penalties. That's part of the HITECH Act. We'll have to wait for the new rule on that one. You have an affirmative obligation to sanction employees who violate HIPAA. If you don't, then that is a separate violation for you. And the covered entity has an obligation to act to stop a business associate's misconduct. If they fail to do so, that covered entity can be liable for its own HIPAA violation. If you're a business associate, you got to be concerned about violating HIPAA because the covered entity may sue you for a violation of your business associate agreement. And HHS is supposedly resuming audits. For all of those reasons, it is important to comply with HIPAA, but wait, not only for those reasons, you also need to comply because, as we're going to talk about, you have an affirmative obligation to narc on yourself, and therefore you want to make sure that you respond appropriately to avoid fines and penalties. All right, with that background, what do you do? So you get back to your office and you find out, oh my goodness, we think that we may have a HIPAA violation. What do you do? Well, don't do this. Things don't get better by simply sticking your head in the sand. That could be willful neglect and subject you to additional fines and penalties if it ever comes to light. Instead, you want to jump on it immediately. So the first thing you want to do is take immediate action to stop the breach. If there's a hole in the dam, you plug the hole. That means if you sent that fax to the wrong entity, you gave the information to the wrong patient, you take immediate steps to get that information back. Don't delay doing that. Because if you take that those immediate steps, you may, in addition to having an affirmative obligation to mitigate, you may be able to stop any improper disclosures and therefore mitigate the potential for a breach disclosure. So train your personnel that if they think that there is a violation, take immediate action that they can do to stop any further disclosure or improper use of the information. Next, train your people to immediately report the information, the potential breach, to the privacy officer. All covered entities have to have a privacy officer. That privacy officer has to be designated in writing. You should train your staff to report that suspected breach to the privacy officer. Why? Because you want to respond to these issues immediately. Immediate response may help you avoid the breach reporting obligation and/or penalties. You may avoid penalties if you correct the violation within 30 days of when you knew or should have known that the violation occurred. In addition, you've got to report that breach within 60 days of when you knew or should have known of the violation. And we'll talk about that more later. Beware your business associate agreements. They may actually require you to make those reports on a quicker basis. And in all those situations, when you do have a suspected breach, you usually want to have your privacy officer step in and investigate. Why? Because it's the privacy officer who hopefully understands HIPAA well enough to determine whether or not there is even a HIPAA violation at issue. So that's the next thing you want to do. You want to confirm whether HIPAA even applies to this potential breach. That depends on whether the action was taken by an entity acting in its capacity as either a covered entity or a business associate. HIPAA only applies to uses or disclosures or conduct by covered entities. Now, covered entities under HIPAA are healthcare providers, but not all healthcare providers. Only healthcare providers who engage in certain electronic transactions, primarily dealing with electronic payments. If you are a pure paper office, then you can generally avoid HIPAA. But that's not most of us, so it's going to apply to almost all healthcare providers, but it also applies to health plans, including employee group health plans with 50 or more participants or that are administered by a third party. So for those of you who are not only a covered entity as a healthcare provider, but who also have a health plan or an employee group health plan with 50 or more participants or that's administered by a third party, then HIPAA would also apply to that information that that health plan maintains. Now, HIPAA, in the wake of the HITECH Act and the Omnibus Rule, HIPAA also applies directly to business associates. So that means if a business associate violates HIPAA, then it can be also subject to HIPAA fines and penalties, and HIPAA imposes certain obligations on business associates to respond. Business associates are those entities that create, maintain, transmit, or use protected health information on behalf of a covered entity. So HIPAA only applies if the alleged misconduct was by a covered entity or business associate acting in its capacity as such. So, for example, a lot of you may be employers. Let's say you breach employment information. Well, if you're doing that not in your capacity as a healthcare provider, not in the course of providing health care, you didn't get the information in your course of providing health care for the employee, then it may be a privacy violation under state law for certain employment protections, but it does not trigger HIPAA. All right, once you confirm that HIPAA applies, you have to determine, or applies to the covered entity, you have to confirm whether or not the information that was used or disclosed improperly is protected health information. HIPAA only protects protected health information. That is information which is created or received by a healthcare provider or health plan, acting in its capacity as such, and relates to the past, present, or future healthcare, or payment for healthcare. And it either identifies the individual or there's a reasonable basis to believe that the information can be used to identify the individual. Protected health information only is individually identifiable health information. Now, with that said, it's very broad. Even the person's name, even if it doesn't contain any additional health information about them, the person's name itself is protected health information. Now, HIPAA doesn't apply to de-identified information. So if you go in and suck out all of the individually identifiable information, so there's no way that that information can relate to a particular individual or can be used to identify an individual, then HIPAA doesn't apply to that. If you have a situation where certain information is disclosed that would otherwise be protected health information, but there's no way to link that information to a specific individual, then HIPAA probably doesn't apply to that disclosure. Now, HIPAA applies to the use, access, or disclosure of protected health information. Note that it's not only the disclosure outside your entity, but also the internal use or access, improper access to the information internally, unless you satisfy one of these 4 standards. We talked about this a couple of weeks ago, but real briefly. HIPAA does not apply, or HIPAA does not prevent uses or disclosures for purposes of treatment, payment, or healthcare operations, so long as you did not agree with the patient to otherwise restrict such uses or disclosures. So most of the disclosures you're going to see are for purposes of treatment, payment, or healthcare operations. And as long as you didn't agree with the patient to keep those confidential, you can use or disclose that information without the patient's authorization, and it's not a breach. In addition, HIPAA has a separate exception for use of certain information for facility directory or disclosures to family members or persons involved in the healthcare or payment if the patient did not object, you otherwise believe it's reasonable to make that disclosure on behalf of the patient, and you think it's in the patient's best interest, and you limit the scope of that disclosure to the role of that person who's receiving that information. That's the second exception. Third exception, you don't need the patient's, or you can make certain disclosures for certain other public safety or government functions, so long as you fit within the requirements in 45 CFR 164.512. Generally, for everything else, you have to have a HIPAA-compliant authorization. Remember that the HIPAA rules also apply not only to breaches by the covered entity, but also breaches by business associates and agents of the covered entity or subcontractors of the business associate. Now, the next issue is that HIPAA also has what's called the minimum necessary standard. So even though HIPAA would allow you to make certain disclosures under these use or disclosure rules, if you disclose more than is minimally necessary to accomplish the purpose of that disclosure, then that is a separate HIPAA violation. Now, that minimum necessary standard does not apply to disclosures to a request by another healthcare provider, uses or disclosures made per an authorization, so long as you complied with the scope of that authorization, or uses or disclosures that are required by law, so long as you don't disclose more than is required by the particular law. So even though HIPAA would allow you to make the disclosure if you disclose more than the minimum necessary, that could actually be a HIPAA violation and result in a reportable breach. Now, incidental disclosures do not violate HIPAA, and therefore they are not reportable. So what's an incidental disclosure? An incidental disclosure is a disclosure that's incident to a use or disclosure that is otherwise permitted by the or required by HIPAA, and the covered entity otherwise complied with the minimum necessary standard and implemented reasonable safeguards. So, for example, you have situations where, let's face it, people see things, people hear things all the time. They're walking down the hospital hallway, they overhear a nurse saying a patient's name, they might see a patient's name on the door, they might see something on the whiteboard. That is probably an incidental disclosure, so long as you implemented reasonable safeguards. In those situations, those are not HIPAA violations, and you don't have to report those. All right. So that's the next thing that you need to do, is to make sure that you look at the situation, the privacy officer investigates and confirms whether or not HIPAA even applies, whether or not there was a violation. Assuming that you conclude that there was a violation, check on your insurance. Many companies carry cyber liability or potentially other applicable insurance, whether it's a CGL policy or an errors and omissions policy. If there's any question about whether or not your potential policy may apply, check with your broker. When in doubt, report it to the insurer. Back before I saw the light, I used to be an insurance defense attorney, and I saw lots of situations where insurance company made mistakes by accepting coverage when there really wasn't coverage. So therefore, my default is, when in doubt, go ahead and report it to the insurance company. If you fail to make a report when you need to, that delay may give the insurer an excuse to deny coverage. If you make that report, even if there isn't coverage, the insurer may accept coverage despite the terms in the policy, because they have a tendency to make mistakes. Finally, the insurer may provide resources to help you respond by going ahead and submitting that. You may get additional help in order to respond. And any time that you're communicating with your insurance company, make sure that you document that in case there is a dispute down the road. For example, there was a recent highly publicized case where an insurance company had to pay about $4 million to help with the data breach, but they subsequently brought a lawsuit trying to get out of that obligation to pay that money. You need to make sure that you have the appropriate documentation in place, that you gave the appropriate notices, and if the insurance company accepted coverage, agreed to coverage, you want to have that documented. Next, you need to investigate promptly. That investigation by the privacy officer or other appropriate person should include the following. Confirm the facts with the persons involved. Don't just assume that you know the facts, because quite often once you interview the witnesses or those recipients, you may conclude, hey, they really did have a legitimate purpose for getting this information that fits in one of those user disclosure rules. Maybe it was for treatment, payment, or healthcare operations, or maybe it was a disclosure to family or others involved in the healthcare. So make sure you confirm the relevant facts with the persons involved, including the person who committed the alleged violations, persons who may have received the information improperly, or other witnesses. Next, you want to confirm, or as part of that, confirm the reason for the user disclosure, because again, under the user disclosure rules, there are certain purposes that allow you to use or disclose the information, so you need to know why that information was used or disclosed. Confirm what information was accessed, used, or disclosed. Was it really information covered by HIPAA? How extensive was the information? That will affect whether or not there is a violation or whether or not the breach is reportable. It will also help you identify what you need to do in order to mitigate the improper disclosure. Confirm the scope of the access, use, or disclosure. Did it just go to one person, or did it go to many people? Did that person who received it, did they disclose it to other people? If they disclose it to other people, you need to follow that chain and contact the other people. After you've made that disclosure, determine what steps need to be taken to mitigate or correct this situation, whether that's contacting people to warn them against further uses, whether that's getting information back, whether that's putting up safeguards, whatever it may do. In all of those situations, make sure that you document the investigation, because when the OCR, if they ever come in, they're going to want to make sure that you took appropriate steps to mitigate. In addition, you're going to want to document that to show that you took appropriate steps to correct the situation and therefore are avoiding HIPAA fines. HIPAA has a specific obligation on covered entities that they must mitigate to the extent practical any harmful effect that is known to the covered entity of a use or disclosure by the covered entity or its business associate in violation of its policies or the privacy rule. So you have an affirmative obligation to take steps to mitigate the damage. In addition, if a covered entity or business associate knows that their business associate or subcontractor is out there violating HIPAA, they've got to take appropriate steps to terminate that violation or terminate the contract. If they fail to do that, then that is a HIPAA violation on behalf of the covered entity. So you need to take prompt steps to mitigate the harm. That could include stopping any further breaches, retrieving, deleting, or destroying the protected health information, contacting recipients to confirm the scope of the uses or disclosures, and again, warn against future uses and disclosures. That's where that criminal statute comes in handy, because you can warn them, hey, really sorry you got that information, thanks for letting us know. Just so you know, you can't further use or disclose this information. If you do, you can be subject to these criminal penalties. That may get their attention. You should terminate access, change passwords, etc. as necessary. Hopefully you've got the technology you need in order to remote wipe hard drives or mobile devices in case they're improperly stolen or lost. So if you can do that, you can mitigate the damages there. Maybe notify affected individuals. We're going to talk about that later. Maybe cover the cost of additional measures such as credit reporting agencies and the like. That's a common mitigating step that a lot of people will do. There is nothing in HIPAA that expressly requires that. It's often done, but there's nothing that expressly requires it, but you do have to take appropriate steps to mitigate whatever that might be. Again, you want to document all of your actions in an investigation file, and perhaps if you're doing that investigation, in letters to the persons whom you spoke with to confirm the facts. For example, If I'm investigating and responding to a potential fact, I will sometimes write a letter to the person who received the information improperly and just say, hey, thanks so much for talking to me. This just confirms our discussion in which you verified that you received the information but did not disclose it to anybody else, and you have completely destroyed the information and you will not disclose it to anybody else. And by the way, these are the criminal penalties that can rain down upon your head if you do that. By putting that type of information in your investigation file, I think that it'll help you if the OCR ever comes to investigate. You can confirm, yes, we took reasonable steps to stop the breach so it didn't go any further. Next, you have an affirmative obligation to sanction your employees. You've got to impose appropriate discipline against your employees and workforce members. If you fail to do so, that is a separate violation on you, and you should document the sanctions. Now, those sanctions should fit the crime. In some circumstances, it may justify immediate termination of employment, especially if it is an extremely serious violation or it's a repeated violation. Maybe if it's just more or less innocent, relatively honest mistake, then it may be something less, anywhere from just simply some kind of a written warning in their file, maybe requiring that employee to undergo additional HIPAA training, or maybe some kind of a suspension. Just make sure that the punishment fits the crimes. Hopefully you have your employment policies or have all of your employees sign confidentiality agreements that warn them of the potential penalties that can apply if they violate HIPAA. Let's see. Okay. 9, next step, correct the violation. This is really important because, as we talked about earlier, it's an affirmative defense to HIPAA penalties if the covered entity or business associate did not act with willful neglect and you correct the violation within 30 days. Well, how do you correct that violation? Because you really can't unring the bell, right? Once that disclosure's been made, how can you correct the violation? It appears that HHS interprets corrected relatively broadly. They have the following commentary. For example, in the event of covered entities or business associates non-compliant, inadequate safeguards or policies result in an impermissible disclosure, the disclosure violation itself could not be fully undone or corrected. The safeguard violation, however, could be corrected in the sense that the non-compliant policies and procedures could be brought into compliance. So, as a part of that correction, you need to do things like mitigate the harm, like we've talked about, sanction the employees, revise policies and procedures if necessary, implement new or different safeguards to avoid such disclosures or improper uses in the future. Train and retrain your personnel, particularly those who are involved in the breach, but not only those, but other people who may face similar breaches. Enforce your policies and rules. Maybe notify affected individuals, we'll talk about later. Take any other appropriate steps that you may need to under the circumstances to correct that situation and help ensure that it doesn't recur. And, as always, document your actions so that if the government comes in there and looks, you can say, yes, this violation occurred or this incident occurred, but we took reasonable and prompt steps within 30 days to correct that situation. And note that you need to take that within 30 days of the time that you determined that there was a violation. On this 30-day rule, it doesn't necessarily run from the time that the breach occurred, but instead it runs from the time that you knew or should have known that the breach constituted a violation of the rules. So you have a little bit of a window, but don't count on it too much. Next, you have an obligation to log an improper disclosure. Remember, one of the patient's rights under 45 CFR 164.528 is a patient has a right to come in and request an accounting of disclosures that you've made of their information, but not all disclosures, only essentially disclosures in violation of HIPAA or certain disclosures for government functions under 45 CFR 164.512. So all of you should be maintaining this accounting of disclosure log. If you fail to do that, that's a violation of the rule and maybe even willful neglect. If you have an improper disclosure, whether or not it's reportable to the government or to the individual, you still have an obligation to record that on this accounting log. So if the patient ever comes in and asks for a copy of that, they can access that. Now, the disclosures you have to account for on that log are the release, transfer, provision of, access to, or divulging in any other manner of information outside the entity holding the information. So you don't have to account for improper uses within your organization, but you have to account for those disclosures outside your organization. That accounting that you have to log has to include the date of the disclosure, the name and address of the entity who received the information, a brief description of the information disclosed, a brief statement of the purpose of the disclosure, or a copy of the written request for the disclosure. As a practical matter, this is going to require you to maintain that log of disclosures as you go along. Now, that's the bad news. The good news is that as long as that you only have to provide that accounting of disclosure if the patient asks for it. You don't have an affirmative obligation to self-report that accounting log disclosure. That's different than the breach notification rule we'll talk about later. But if the patient does come in and request an accounting of disclosures, you have to be able to produce that log, and that patient may look through there and decide, oh, wait a minute, there are violations here, we're going to turn you in, but you have to go ahead and maintain that log. Now, under the proposed rule, under the HITECH Act, the proposed rule that the government issued, that HHS issued, would expand that accounting of disclosure requirements if you maintain electronic health records. Their theory is that if you maintain electronic health records, hey, those programs ought to be able to track any disclosures you make of the information, including disclosures for treatment, payment, or healthcare operations. And therefore, under the proposed rule, a patient has a right to come in there and request a log, not only of the improper disclosures, but any disclosures you've made, including disclosures for treatment, payment, or healthcare operations. Now, right now, this is a proposed rule. We don't have the final rule. We'll have to watch for that, but just note that that may be coming down the pipe. If you're shopping out for an electronic health records program, you may want to look at this and make sure that it's got the functionality you may need down the road if the rule is going to actually require you to track that and be able to generate reports for patients concerning disclosures of information you've made. Next, if you're a business associate, that business associate has an obligation to report breaches to the covered entity. The business associate must report the following: any use or disclosure of protected health information not provided for by the BAA, the Business Associate Agreement, of which it becomes aware. So even though there wasn't a privacy rule violation, if there was a use or disclosure that violated the Business Associate Agreement, that business associate still has an obligation to report that to the covered entity. In addition, the business associate has to, at least under the security rule, report any security incident of which it becomes aware. Now, security incident is defined incredibly broadly as the attempted or successful unauthorized access, use, disclosure, modification, or destruction of PHI or interference with the system operations in an information system. Note that it applies to attempted incidents, not just successful incidents. We'll stop and think, if you're an IT guy, you're thinking, well, wait a minute, we get hundreds, if not thousands, of pings a day. Do we have to report each of those? Under the security rule, the answer is, yeah, you're supposed to, but that's just completely irrational. So therefore, in my business associates, I'll put in something to the effect of, hey, you acknowledge that we get lots of unsuccessful pings a day. This constitutes notice that we get those, and we're only going to report successful pings, and I think you probably ought to be okay in those situations. In addition, the business associate has an obligation to report breaches of unsecured protected health information that must be reported under the breach notification rule, which we'll talk about that in a few minutes. Your business associate agreements often contain additional terms. So if you're a business associate, you want to look at that business associate agreement and see if there are additional requirements placed on the reporting requirements or your obligations in the event of a breach. It may require you to make reports in a shorter period of time. It may require you to step in and actually do the breach reporting or cover the cost of the breach reporting. It may require you to indemnify the covered entity for the breach reports. Make sure you take a look at the business associate agreement when it comes time to responding. If you're a covered entity, conversely, you want to also take a look at the business associate agreement to make sure that you understand what your rights are as opposed to the business associate. That brings us to the breach notification rule. Dun, 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 dun. Under the breach notification, you're required to report a breach in certain circumstances. If there is a breach of unsecured protected health information, a covered entity must notify each individual whose unsecured protected health information has been or is reasonably believed to have been accessed, acquired, used, or disclosed. In addition, you always have to, anytime you notify the individual, you also have to notify HHS. The only difference is the timing. And if the breach involves more than 500 persons in the state, you've got to also notify local media. Those are the obligations of the covered entity. The business associate has an affirmative obligation to notify the covered entity if its people, if there's a breach of unsecured protected health information by its people. Now, it only applies to a breach of unsecured protected health information. What's unsecured protected health information? Well, it's information that's not secure. Well, what's secured information? Only two ways currently to secure your protected health information against breaches. The first, if it's electronic information, is to encrypt it according to the standards that the government sets out. So if you've got properly encrypted electronic information, even though it's lost or stolen, that is not a reportable breach. You may still have an obligation to account it on your log, but it's not a reportable breach if it was appropriately encrypted. The second way for all other data, as well as electronic information, is to completely destroy it. I always thought that was kind of a curious one because if it was completely destroyed, how could you ever disclose it anyway? How could there ever be a breach? But nevertheless, that's the other way that you can secure your information. Now, most of your information is not going to be secure. So really, what we focus on most when it comes to the breach notification rule is whether or not there is a breach of unsecured protected health information. What is a breach? Well, the rule says that the acquisition, access, use, or disclosure of protected health information in violation of the privacy rules is presumed to be a breach and reportable, unless the covered entity or business associate demonstrates that there is a low probability that the information has been compromised. There's the test, that there's a low probability that the information has been compromised. How do you determine that? Based on a risk assessment of the following factors. Those 4 factors there, we'll come back and talk about it. Unless an exception applies. HIPAA, the breach notification rule contains 3 exceptions from the definition of breach. The following do not constitute breaches and therefore are not reportable. The first is if you've got the unintentional acquisition, access, or use by a workforce member, if made in good faith, within the scope of their authority, and there's no further disclosure of information. This is a situation, maybe you've got an accounts payable person and they're looking at the records and they happen to look at the wrong person's records. Well, it was an improper access, but hey, it's not a breach under this standard. The second example, that's the inadvertent disclosure by an authorized person to another authorized person at the same covered entity. This is a situation where maybe you've got a physician that comes out and says, hey, nurse, I need you to get this information on this particular patient, only to realize that he asked the wrong nurse. That nurse had no contact with that patient. It wasn't the right nurse. They've disclosed it to the wrong person. Hey, that could be a HIPAA violation, but it's not a breach. Actually, I question whether it's not even a violation. It seems to me an incidental disclosure. But anyway, it's probably it's going to fit within this exception for a breach. The third one I think is the most interesting. It is not a breach if there's a disclosure of protected health information where the covered entity or business associate have a good faith belief that the unauthorized person receiving the information would not reasonably be able to retain the information. Well, what does that mean? Does that mean if the person has a bad memory, that's not a reportable breach? Well, we don't know exactly, but the 2 examples that they gave are, let's say, a covered entity sends out a bunch of EOBs. And some of those EOBs are returned unopened. In that situation, the government says, hey, you could probably conclude in those situations that the individual was not able to retain the information, and therefore it's not a reportable breach. For the unopened EOBs, the EOBs that were opened, hey, that's another matter. All right. Another example that they gave is you have a nurse that comes out to give discharge instructions to the patient. She hands them to the patient only to realize that, oh my goodness, that's the wrong patient. She immediately retrieves that back from that particular patient. The government says in that situation it may be a situation where the patient would not reasonably be able to retain the information, therefore it's not a reportable breach. Okay. Those situations really don't cause you much heartburn. You probably didn't even think that they were reportable anyway, and by the way, you're right. What we're really dealing with most of the time is whether or not there is the unauthorized access, use, or disclosure, and that depends on whether or not there's a low probability that the information has been compromised. Compromised. What the heck does compromised mean? Well, quite frankly, I've been looking at this ever since the new omnibus rule came out with the new standard for the past 3 years, and I still don't know what compromised means, other than you look at it based on those 4 factors. Does it mean that the information is actually acquired or viewed? No, not necessarily, because whether or not the information was actually acquired or viewed is only one of the 4 factors in the test. You may have a situation where you have no proof that the information was acquired or viewed, but it still may be subject to the breach reporting. For example, if you've got a situation where you've got a lost laptop or a lost USB and they're unencrypted and contain a bunch of information, the government takes the position, hey, that's probably a reportable breach, even if you don't have reason to believe that it's been improperly accessed. So, how do you determine whether or not the data has been compromised? Well, you do it by going through that risk assessment of these factors. The first, the nature and extent of the information involved, including the types of identifiers and the likelihood of re-identification. Second, the unauthorized person who used the information or to whom the disclosure was made. Did it go to another physician who was otherwise obligated to maintain the confidentiality, or did it go to the local loan shark? 3, whether the PHI was actually acquired or viewed, but that's just one of the factors. 4, the extent to which the risk to the protected health information has been mitigated. Did you jump on it so quickly that there really is no significant risk at all involved? Number 5, any other factors as appropriate under the circumstances. So that's how you determine whether or not there's a low probability that the data has been compromised. You would want to consider each of those factors, document your conclusion. Now, if you don't like those risk assessments, you don't have to do the risk assessment if you don't want to, but then you're going to have to make the report. If you don't want to make the report, then you need to do that risk assessment and you need to document it. Now, we don't have a lot of guidance on how you would apply that stuff, but the commentary that came out with the omnibus rule gave some examples of that the following situations would likely involve a lower probability that the information would be compromised. For example, maybe the fax is sent to the wrong physician, but that physician reports that they received the fax and confirms he's destroyed it. In that situation, probably a low probability that data has been compromised, including the fact that that physician is otherwise, covered by HIPAA, knows HIPAA, and generally would keep that information confidential, so it's maybe a low probability that data has been compromised. If that fax went to the local tire shop, however, maybe not the same factors involved. Next, another example, the disclosure to or use by persons who are required by HIPAA to maintain the confidentiality. We already talked about that. Next example, the disclosure without identifiers or to an entity that lacks the ability to re-identify the information. So maybe you send a bunch of the hospital data to the wrong party, but there's no identifiable information on it, nothing to link those identifiers back to the individual, or maybe you've got account information, but there's nothing that also includes the code for that. That account information itself, though, that may be a little bit suspect because people could probably misuse that, and I think that's probably dangerous in and of itself. Next example, a stolen laptop is recovered and an analysis shows that the PHI was not accessed. In that situation, you may conclude that there's a low probability that the data has been compromised, but you have to look at all the other factors. On the other hand, the government has said that the following situations likely involve a higher probability that the information is compromised. The disclosure involves financial data like credit card numbers, social security numbers, etc., sensitive information like sexually transmitted diseases, mental health, or other information, or detailed information, things like treatment plans, diagnosis, medications, medical history, test results. I sometimes get the question, well, how much information has to be disclosed before it becomes a reportable breach? The answer, we don't know, and it depends on the type of information. Now, in the prior version of the breach notification rule, the one that came out before the omnibus rule, the government gave the example of a situation where basically, hey, if all you disclosed was the name of the person and the fact that they were receiving treatment at a hospital, that's probably not reportable under that standard, under the prior standard. It would maybe be different if that person was disclosed to be a patient at a mental facility, or that patient's, not only their name, but also some additional information was disclosed about, and that might be different. But simply the name may not be sufficient. Now note that that was decided under the prior standard before the omnibus rules came out. Under the prior standard, the standard was whether or not there is a substantial risk of financial, reputational, or other harm. The prior rule was this harm standard. When the omnibus rule came out, they changed the harm standard. The test is not supposed to be whether or not it would result in harm to the individual. Don't keep using that harm standard. That has to be a factor in the compromise, but it's not the only factor. You have to look at those 4 factors that the government's identified. All right, next factor the government suggested would suggest a higher probability the information is compromised. The disclosure involves a list of patient names, addresses, hospital IDs. The key here is that it's not just the names, but it's additional information beyond that too. Or if the information is mailed to the wrong individual who opened it and read it, and the person is not a covered entity or business associate. In that situation, there's a higher probability that the data has been compromised, but even then you would look at the overall facts. What was the information that they looked at? Did they really look at it, or was there just a risk? You have to look at all of these factors. HHS has said that they'll issue future guidance regarding common scenarios. They said that 3 years ago, still haven't seen anything. Well, I guess we'll wait to see. Now, that is the standard for breach notification. So to briefly summarize that, no breach notification is required if there was no privacy rule violation. Breach only applies to privacy rule violations. If there is no privacy rule violation, then there is no reportable breach. Specifically, incidental disclosures are not privacy rule violations, and therefore they're not reportable. Second, there's no breach notification required if the PHI is secured. For example, in electronic information, if it was encrypted per HHS standards, even though you lose it, if it's secured, it's not a reportable breach. Hey, that is really important for you guys who maintain laptops or mobile devices. You want to make sure that stuff's encrypted, because if you don't, and it's lost, the government takes the position that's reportable. And by the way, each separate person's name that's on that laptop, each patient's name on that laptop, that's a separate violation. In addition, if you fail to have the encryption standards or fail to otherwise comply with the security rule safeguards that should apply to that laptop or your mobile device, like passwords, things like that, every day you didn't have that in place, a separate violation. So you really got to take your laptops, mobile devices, USBs, you got to make sure that you safeguard those. If you don't and you lose those, hey, the government thinks that's a reportable breach. The unauthorized recipient is unable to retain the protected health information. For example, if they send out the EOBs come back, they're unopened, then in that situation you conclude there's a lower probability. Finally, there is no reportable breach if there is a low probability that the data has been compromised. Now, in all of those situations, the covered entity has the burden of proof. If you need to establish that the breach is not reportable, the government's going to say, okay, prove it to us that that breach was not reportable, because remember the standard? The unauthorized access, use, or disclosure of protected health information in violation of the privacy rule is presumed to be a breach, unless you can demonstrate that there's a low probability the data has been compromised. Now, because you carry that burden and because that breach standard is relatively low, until we receive further clarification from HHS or the OCR, it's safer to err on the side of reporting all but clearly inconsequential breaches. If you fail to do so, the government may say, hey, even though the initial breach was not willful neglect, your decision not to report that may be willful neglect. The government gave this following example. A covered entity's employee lost an unencrypted laptop that contained unsecured protected health information. The covered entity feared its reputation would be harmed if the information about the incident became public, and therefore decided not to provide the notification as required by the rule. In that situation, the government said, hey, that's willful neglect. If it's willful neglect, mandatory fine of at least $10,000 per violation. And by the way, each person's name on that laptop, separate violation. And you can't correct it. You don't get the benefit of that correction rule if you act with willful neglect. And therefore, I err on the side of doing the breach report. Now, frankly, if you've got that potential breach of unsecured information, it kind of puts you in a tough situation.
if you go ahead and you do the report, it's going to significantly reduce your risk of penalties because it'll probably, the initial breach probably wasn't willful neglect. If you go ahead and do an appropriate report, you're probably going to be able to avoid the willful neglect penalties. If you correct it within 30 days, no penalties. Even if you don't correct it within 30 days, you can still get hit up with penalties, but they won't be as severe as if you failed to report. On the other hand, if you do make the report, well, hey, now you basically knocked on yourself to the government. There's a risk the government could come in there and do an OCR investigation. You're going to have to notify the individual. That could, the individual could then try to pursue claims against you. They could turn you into the AG, and you're going to have the cost of reporting and responding to potential breaches. You may feel like you're left with this guy. You're damned if you do, damned if you don't. But I think you're probably safer in doing the report, especially if you do the report no later than 60 days. If you don't think it involves more than 500 persons, then you do the report no later than 60 days after the end of the calendar year when everybody else in the United States is doing their breach report. It goes in there with everybody else's. The government's overwhelmed. They don't realize that all of these come in and it never sees the light of day. So you've gone through that analysis. You've now concluded that there is a breach of unsecured protected health information. What do? Well, the covered entity must notify each individual whose unsecured information has been or reasonably believed to have been accessed, acquired, used, or disclosed. You've also got to notify the government. If the breach involves more than 500 persons in the state, you've got to notify local media. Let's talk about the notice to the individual. You've got to provide that written notice to the individual without unreasonable delay and in no case later than 60 calendar days after discovering the breach. Now, a couple of comments here. Note that that 60 days runs from the time that anybody in your organization knew of the facts surrounding the breach except the person who committed the breach. But if there's anybody else in your organization who knew about it, that triggers the 60-day clock. It doesn't begin to run from when the privacy officer knows about it or when administration knows about it. It doesn't begin to run when you figured out that it's actually a privacy breach. It runs from the time that the breach occurred, from when the first person knows about it that the breach occurred. So that 60-day time clock starts ticking pretty early. In addition, the government says, hey, you've got to report without unreasonable delay. That means you can't necessarily wait till the 60 days and be safe. If you can step in and do your investigation in 2 weeks, then the government says you better be reporting at the end of the 2-week period. You can't wait for the 60 days, so you got to jump on this and act as quickly as possible. To that end, you should train your workforce to report promptly. Make it part of your policy and tell them they can be subject to sanctions if they don't report promptly. You want them to report promptly. Why? So that you can act to mitigate it, which may avoid your breach notification requirements, so that you can correct it within the 30-day period, and that you can do the proper report within the 60-day period. To that end, you may also want to require your business associates to report promptly so that for all of those reasons. Now, that notice to the individual has to contain the following: a brief description of what happened, including the dates of the breach and discovery, a description of the types of unsecured information that was involved, for example, did it involve name, social security number, date of birth, etc., the steps that you're taking or the steps that person should take to protect themselves from harm resulting from the breach, a brief description of what you are doing to investigate, mitigate, and protect against future breaches, and contact procedures so that the person can contact you to ask questions, including a toll-free phone number, email address, website, or postal address so that they can call you to ask questions. That notice to the individual has to be sent by first-class mail to their last known address. I always figured this was the way that the government was going to keep the post office in business because they require you to send it by first-class mail. By the way, even if it's the patient who reports the breach to you or complains about it, even if they know about it, the OCR still expects you to send that letter to them. You can provide that notice by email if the individual has agreed to accept it by email. What about if the individual is deceased? Well, in that situation, if you have the address of the next of kin or personal representative, you've got to send that notice by first-class mail to the next of kin or personal representative. If you don't have that address for the next of kin or personal rep, you don't have to send it to them. In urgent situations, you may also contact the patient by phone or other means but that doesn't mean that it exonerates you from sending the written notice. You still have to send the written notice. What about if you don't know where the person lives anymore? Well, if you lack sufficient contact information to provide written notice to the individual, you must provide a substitute form reasonably calculated to reach the individual. The type of form depends upon the number of persons for whom you don't have reasonable contact information. If there's less than 10 such persons, then you may use an alternative form of written notice like telephone or other means. If there's 10 or more such persons, then you've got to post conspicuously on your covered entity website the required notice for 90 days, or posted in the major print or broadcast media where the affected individuals are likely to reside, and you've also got to include a toll-free number for at least 90 days. Now, that's the notice to the individual. If you do have a potential breach situation where you have to give notice, I encourage you to either crack the regulations and look through the regulations to make sure you understand it, or look at the other materials I provided to you, including my article and or my breach notification policy, which should walk you through the steps. Anytime you give notice to the individual, you're also going to have to give notice to the government, to HHS. The only difference is the timing. If the breach involves fewer than 500 persons, you have to submit your notice to HHS annually within 60 days after the end of the calendar year in which the breach was discovered, which, depending on whether or not it's a leap year, I guess is March 1st. Hence, we scheduled all these HIPAA webinars so that you would get the information you need so that you can do your breach reporting by March 1st of this year. If the breach involves 500 or more persons, then you can't wait. You've got to notify HHS contemporaneously with the notice to the individual or the next of kin. That means without unreasonable delay, but within 60 days. The way you submit that report is you go to that website on the government's, on the slide there, and it has instructions there for doing your breach reporting. You submit that notification electronically. There's a lot of detailed information that they'll ask about. You just fill out the form electronically and go ahead and submit it. If the breach involves more than 500 persons, then your name gets added to the OCR's wall of shame for all of those entities who've had breaches involving more than 500 persons. If the breach involves unsecured protected health information of more than 500 residents in a state, you also have to notify prominent media outlets serving that state. For example, issue an appropriate press release. Note, however, it only applies if the breach involves more than 500 residents in a state. So let's say that you live in a border town and you have the breach involves 300 persons in state A and also 300 persons in state B. You don't actually have to do the breach report to the media in that situation because it doesn't involve more than 500 persons in a particular state. Kind of a weird little nuance, but there you go. You've got to provide that notice to the media without unreasonable delay, but no more than 60 days from the discovery of the breach. You generally have to include the same kind of content as the notice to the individual. The whole purpose of this is to notify persons of these potential breaches. For heaven's sakes, don't be disclosing any additional protected health information in your notice to the media. If you're a business associate, you've got to notify the covered entity of the breach of an unsecured protected health information without unreasonable delay, but no more than 60 days. If I'm a covered entity, I want to narrow that down and require the breach report in a substantially shorter time so that I can mitigate and correct the situation. That notice by the business associate has to include certain information, including identification of the individuals affected and other information that's necessary to enable the covered entity to make its breach report to the government. Now, note that the report to the government and to the individual, that is the responsibility of the covered entity. The business associate's responsibility is to make the report to the covered entity so the covered entity can make the report to the government or the individual. The business associate agreement may transfer that responsibility onto the business associate and have the business associate responsible for giving those notices. You have to look at your business associate agreement. There are certain circumstances where law enforcement may delay those disclosures. That doesn't happen very often. If you do have law enforcement involved, check the rule. All right. That is my overview of responding to breaches. To briefly summarize, if you think you have a breach, act immediately to minimize that breach. Stop the breach. Stop the information going out. Retrieve whatever information you can to mitigate the damage. Next, notify your privacy officer immediately. Confirm whether that privacy officer should confirm whether HIPAA applies or whether HIPAA was violated. Check on available insurance. Investigate promptly. Mitigate any harm. Sanction workforce members. correct any process that resulted in the improper disclosures, or otherwise take appropriate steps to correct the situation. Log the improper disclosure on your accounting disclosure log. If the breach is reportable, if it's an unauthorized access, use, or disclosure in violation of the privacy rule, and there is more than a low probability that the data has been compromised, then you're going to have to do the breach reporting and document all of the foregoing. Remember, prompt action may allow you to satisfy your duty to mitigate, avoid disclosure and breach reporting obligations, because remember, mitigation is one of the factors in the breach notification risk assessment. If you acted immediately and were able to mitigate any kind of risk, then you may be able to avoid breach reporting. And if nothing else, it allows you to defend against HIPAA penalties. To determine if a breach is reportable, ask the following questions. Was there unauthorized access, use, or disclosure of protected health information, of unsecured protected health information? If so, did it violate the privacy rule? If so, does one of the exceptions apply? Was it just those internal disclosures with no further risk, or was it improbable that the information has been, retained by the recipient? If so, then you may fall within one of those exceptions to breach reporting. If not, however, you have to do that risk assessment, all geared towards, is there a low probability that the data has been compromised? Make sure you document that. If you conclude that there is more than a low probability, then you need to go ahead and do the breach reporting. Finally, as I mentioned at the start, check your additional state laws. It's possible your state laws may have more strict or additional rules for doing breach reporting. Make sure that you are aware of those. Finally, responding to possible HIPAA violations, remember, a good offense is your best defense. You want to actually act to minimize your potential exposure up front before the breach occurs. Because if you do certain things, even if a breach occurs, you can avoid willful neglect penalties and you can mitigate your exposure. So, act to minimize exposure before a violation occurs. Make sure you know the rules. Make sure you implement the required HIPAA policies and safeguards. If you're wondering what those were, you can look at our last 2 webinars. You need to train your employees regarding the policies and safeguards. Why? Because if you had those policies and safeguards in place, you trained your people, and you just have a rogue employee out there, hey, you can tell the government, we didn't act with willful neglect. That employee screwed up, but we didn't act with willful neglect. If we correct it within 30 days, you can avoid penalties. You should execute confidentiality agreements with your members of your workforce, your employees, and you also have to execute your business associate agreements. You should respond immediately to a suspected breach and make sure you document the foregoing. Now, if you go through all of this, it's possible that the OCR may still send you a request for an investigation. Usually what will happen is they will send you a letter telling you that they got a complaint, they want you to provide certain information. When you go ahead and respond to that, consider contacting somebody who knows about HIPAA to help you with the response. In your when the government requests or asks for an investigation, make sure you're cooperative. Your credibility is one of your most important assets in dealing with the government. One of the highest HIPAA penalties so far was for $4.3 million. About $1.3 million of that came because the covered entity failed to grant access as required by HIPAA to patients. The remaining $3 million came because the individual failed to cooperate with the OCR's investigation. You don't want to blow off the OCR if the OCR comes knocking. When you do submit your response, make sure you bring out these points in your response. Make sure you confirm that you have the appropriate policies in place, that you had conducted appropriate training, and hopefully you've documented that, and you've got confidentiality agreements by the relevant persons that you can provide it, that you can show, yes, we provided the training for these people. We have the policies. They even signed a confidentiality agreement, and guess what? They just screwed up. We responded immediately and appropriate to mitigate any harm. We have taken corrective actions. Cite the commentary in the rules, confirming that there's no penalties warranted in these situations. Whenever I've done this on behalf of a client, so far, knock on wood, I've never had one of my clients get hit up with any HIPAA fines or penalties, because we've always been able to show that even if there was a breach, that we did not act with willful neglect, we corrected it within the 30-day time period, and therefore we are not subject to penalties. For additional resources, the government has a great website dealing with HIPAA. You can just Google OCR and HIPAA. It'll take you to the government's website, including a whole bunch of information for healthcare professionals. We also have a bunch of resources on our website, and guess what? It's all free, including webinar recordings, articles, forums, checklists. I am admittedly a HIPAA nerd. I enjoy HIPAA, much to my wife's chagrin. And so we publish a lot of this stuff that's available for you if you have any questions about that stuff. You can access it through our website. The link there is on your screen. That brings us to the end of today's webinar. Next week, we are going to cover a special feature. As you may know, the government just issued its new repayment rule. One of my partners, Pia Dean, is going to cover the requirements of that new rule for reporting and making repayments. If you would like to participate in that, we will be sending out, I think we have actually already sent out an invitation for that. If you would like to participate in that or receive additional client alerts or notices of webinars, just shoot us a quick email. We'll get you added to the list. And that is it. Thank you all very much. If you have questions, feel free to submit it using the chat feature or shoot me an email afterwards, and I will do my best to get back to you. In the meantime, I hope you all have a great day and respond appropriately to those HIPAA breaches.